There's a lot of confusion about what campus carry means in Texas. In this video, we're going to break down what campus carry means and what it doesn't mean so that you know whether or not you can carry a handgun when you're on a campus. Campus carry in Texas specifically refers to the ability of an individual who has a license to carry a handgun on public institution property. And when we talk about public institutions, here we're talking about colleges or universities. So let's break that down in greater detail. In 2016, Texas passed the campus carry law. And at the time, it applied to individuals who were 21 or older who obtained licenses to carry, previously called a concealed handgun license. And it applied to public universities and colleges. When this law was drafted, private universities and colleges were given the option of opting into this law. None of the major universities or colleges in Texas have opted in to campus carry. The only private institution that has opted in is a small college called Amberton. Other than that, none of the private institutions that may come to mind in Texas have opted in to campus carry. So as a starting point, remember campus carry applies to public universities, and it applies to all the public universities and all the public colleges in Texas. The next requirement is that the individual has to have a license to carry. As I said, when this law was developed in 2016, that applied to individuals 21 or older. Yet last year, a federal court opinion out of Fort Worth said that it does not make constitutional sense for a person who is 18, 19, or 20 to be restricted from obtaining a license to carry. In other words, your Second Amendment rights should apply once you're an adult at the age of 18, and you should be able to apply for that license to carry. As a result, now you can have a license to carry from 18 on up, and therefore this law, campus carry, applies to anyone who is 18 or older as long as they have a license to carry. So what is a campus for purposes of campus carry? Well, a campus includes all of the land and buildings owned or leased by the institution. Can a college or university put restrictions within that campus on where firearms may not be possessed? They can, within some guidelines. The way the law reads in Texas is a college or university can restrict where a firearm is possessed on campus as long as they do not generally prohibit or have the effect of generally prohibiting license holders from carrying concealed handguns. So in other words, and to use an example, a university might be able to say, hey, we are not going to allow a handgun into an area where we know K through 12 education might be going on, even though this is a college campus. Similarly, it's a universal rule that you can't bring a gun to a intercollegiate athletic event, even though that is technically on a college campus. It's on grounds that's owned by a college or a university. So some limitations may be placed. However, the limitation cannot have the general effect of prohibiting a firearm. Understand that campus carry applies specifically to handguns. And why is that? Well, if you look at what the license to carry is allowing you to do, it's allowing you to possess a handgun. It has nothing to do with rifles, shotguns, or any long gun. Another important thing to keep in mind when we're talking about campus carry is the carrying of the handgun must be in a concealed manner. So you can have it in a holster, you can have it on your person, you can even have it about your person, which means concealed in something that belongs to you within essentially arm's reach. It could be a backpack, it could be a purse, as long as you can get to it without having to move your entire body or walk over to it. All of those things would be considered concealed. If you intentionally or knowingly display a firearm while you're on campus, that is at the very least going to be a Class A misdemeanor, which is punishable by up to a year in jail. Of course, if the firearm were brandished to threaten someone else, you might now be looking at aggravated assault, which is a second-degree felony. And there are other offenses that might come into play for displaying a firearm. Remember, if you're taking a handgun onto a college campus, that's a public college or university, and you have the license to carry, it must still be concealed. And that can be confusing at times because lots of Texans know that we've passed open carry. Open carry does not apply on a college campus. When we're talking about campus carry, we are talking specifically about concealed handguns. Additionally, despite the name campus carry, this has nothing to do with middle schools, elementary schools, or high schools. We're talking about institutions of higher education specifically. And with the exception of Amberton, we're talking about public colleges and universities. So what would happen if you took a handgun to a college campus that was either private and therefore does not fall under campus carry, or you took it to a public college or university and you don't have a license to carry? Well, this is a serious felony offense. In fact, possession of a firearm on a college campus without a license to carry, or simply at a private university or college, is going to be a third-degree felony. That means it's punishable by 2 to 10 years in prison and up to a $10,000 fine. If you'd like to learn more about gun laws in Texas, when you can use self-defense, or when you can stand your ground, be sure to check out the pinned comment below, check out our other YouTube videos, and we have articles related to your Second Amendment rights on our website, versestexas.com.